For reasons mentioned in the judgment, the charge sheet number 6/2020 dated 18/1/2020 filed in Bomdila Police Station case number 28/28 corresponding to GR case number 114/2018 and the consequent criminal proceeding pending in the court of Learned Chief Judicial Magistrate Bomdila West Kamen District are hereby quashed and set aside.
Chiefly of that.
Lordship, may I beg to mention item number 1? I'm appearing on behalf of Mr. K. Tama. Learned Counsel is out of station, so therefore matter may be listed on 11th of September. And I have also taken the concern from opposite party.
What's her name?
T. Dotung.
Mr. T. Lompung.
Dotung. D-O-D-U-N-G.
T. Dodung, who prays for an adjournment on the ground that the conducting counsel, Mr. K. Tama, is out of station and prays for listing this case on 11th of September. He also submits that he has taken the consent of the learned counsel for the respondent side. The prayer is allowed. Let this matter be listed on 11th of September.
Lordship, I beg to mention item number 21 and 22. I'm on the behalf of Senior Counsel Udeka. Finally, this matter may be listed after 3 weeks.
Ground.
My senior got some sudden stroke and he's under treatment.
Mr. Udeka.
Udeka,
Heard Miss. What's your name?
me.
Your name.
Dirilong.
D.
Rilung. Dirilong. Dusurilong.
D. Rilo, learned counsel for the appellant who submits that our senior, who is the conducting counsel in this appeal, is indisposed, and on that ground she prays for an adjournment. She has also submitted that she has informed the learned counsel for the
Taken consent.
and taken consent of the learned counsel for the respondent side. Considering the grounds mentioned, the prayer for adjournment is allowed. Let this matter be listed after
3 weeks.
3 weeks.
My Lordship, I would like to mention item number 9. Your Lordship, kindly this matter may be listed on 12th of September. Since the main counsel in this matter is from Guwahati, due to of some personal reason, he couldn't come. And I have taken consent from other party.
You are for
Appellant,
appellant side. What's your name?
Tenzin Choten, T Choten,
Heard Miss T.
Choten, C-H-H-O-T-N.
Choten, learned counsel for the petitioner, who learned counsel for the appellant, who submits that due to personal difficulty of the conducting counsel for the appellant, this matter may be adjourned for how many? Adjourned for 3 weeks.
12th September.
May be fixed on 12th September. She also submits that she has taken consent of the learned counsel for the respondent side for the said adjournment. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on 12th September accordingly.
Oblige, my Lord.
My Lord, I'd like to mention item number 7 and 8. That as my senior is not present today, he was out of station. So matter may adjourn and list after 3 weeks.
Who is your senior?
and
Your,
petitioners on behalf of petition.
what is the name?
N. Karga,
Your senior's name is N
G. Kato,
G.
Kato,
Heard Mr. N Kaga, that counsel for the petitioner who prays for an adjournment due to unavailability of his senior Mr. G. Kakato. Who is for the other side?
yes, I have taken consent from the
He also submits that he has obtained consent for this adjournment from learned counsel for the other side. Considering the submissions made by learned counsel, the prayer is allowed. Let this matter be listed on
after 3 weeks.
after. Let this matter be listed after 3 weeks.
Plus,
Lordship, I'd like to mention item number 25 on behalf of the leading counsel for the petitioner, Mr. Tabatarun. As due to personal reasons, he couldn't make himself available.
Mr.
And L. Tikha,
L.
Tikha,
Tikha, learned counsel for the appellant who prays for an adjournment on the personal difficulty of leading counsel for the appellant, Mr. T. Tagum.
T. Tagum.
You have informed the other side.
We are not aware who is appearing for the other side, as this cause list does not reflect.
Considering the submissions made by learned counsel for the appellant, the prayer for adjournment is allowed. Let this matter be
For
listed
2 weeks.
after 2 weeks.
number 24.
May I, Your Lordship? Lordship, this is a joint application under section 482 of CRPC, whereby the parties are praying for quashing of the criminal proceeding that is pending before the special judge UPR in connection with Women PS case number 120 of 21, Your Lordship. And it has been charge sheeted against the alleged accused under section Lordship will see 376 2F 506 34, read with 6 and 21 of
What is
POCSO.
376 2F?
Your Lordship, that is with connection to rape that is in custody of the parent. Your Honor. If I may be allowed.
Whether 376 matters 482 can be invoked.
Lordship,
This power under 482.
Your Lordship, this is a joint.
on leave. So we have also submitted the pre-arrest bail order copy before the officer in charge, Nalagan Police Station. This is a case of Nalagan Police Station. Due to non-availability of IO, further investigation or bail bond execution could not take place, Your Lordship. This is the copy we have.
CD has arrived.
Lordship, we could not receive the CV also, Lordship.
CD has not arrived.
No, Lordship.
So let us call for the CD. In the
Yes.
meanwhile, you appear. We will
Yes, yes,
extend the
possible.
time period of
Yes.
3.
Still, we are trying to contact with the IO. We don't know exactly from which date to which date he is on leave. So we went before the OC also, appear before the OC.
Okay, we will make it open. Mr.
A Bhattacharya.
A Bhattacharya, learned counsel for the petitioner. Also heard Ms. L. Hage, learned additional public prosecutor. Learned counsel for the petitioner submits that by order dated 30/8/2023, the petitioner, namely, what is the name? Petitioner, namely
Yagum Kabak, Srimati.
Srimati Yagum Kabak, was allowed to go on interim anticipatory bail by this court with a condition that she shall appear before the investigating officer of
Within 3 days, Your Lordship, from the receipt of
investigating officer of which case?
Nalagan PS case number
Naharlogan PS case number
111.
111/23 within 3 days of the date of the said order. Stop. It is submitted by learned counsel for the petitioner that accordingly, the petitioner approached. Petitioner went to the Naharlagun police station. However, he could not meet she could not meet the investigating officer as she was not available. And,
Iowa, he was, Iowa is.
and as Iowa investigating officer was not available. And accordingly, the petitioner reported her attendance to the officer in charge of Naharlagun police station. Thereafter also you went.
4th September, she again went after knowing that Iowa was not
It
there.
is further submitted that thereafter on 4th September, the petitioner again went to the Naharlagun police station to appear before the investigating officer. However, on that day also, she could not find the investigating officer. Stop. On the other hand, learned additional public prosecutor submits that though the case diary was called for, however, same has not arrived. And she prays for fixing another date for producing the case diary. The prayer is allowed. Let this matter be listed again on
13 September.
13th of September 2023. The interim bail granted to the petitioner shall continue.
Your Lordship, I pray that interim may be continued.
Interim shall continue till next date.
And I may be produced lordship updated case diary.
The learned public prosecutor is requested to produce
Updated case diary.
the updated case diary. In the meanwhile, the petitioner shall appear,
Yes,
again
if we get information that Iowa is there, we'll
appear before the investigating officer as and when he is available in the Naharlagun police station. Let this case be fixed again on 13th of September.
Or Your Lordship, I pray on 14 is better, 13, I don't want.
Okay, 14th of, make all 13 into 14.
14. TP of Lordship.
Outline.
If this one-
May I please? The main accused has been released on bail by order dated 38/2023.
How many accused are there?
3.
What is the offense?
Offense is 326, 427, and 34. Where are these? Matter
Main accused released on bail when
30th, I'm furnishing the order.
yes.
In
How
this,
many days you are behind? the bar?
27, I was detained. My lord. Actually, my lord, the incident occurred on 28th. Then I was called by the IO on 27th after 6 days. And then thereafter I was arrested there. And no more custodial interrogation is required, my lord, on 30th/8/2023 has already been sent to a judicial custody, my lord.
What is the acquisition? What FR says?
How is it?
Where is the FR?
If I page 12.
Yes.
May I assist reading out, my lord?
Yes, please.
Subject F5. with due respect and humble submission that I have been brutally attacked by so and so along with his gang member on 28/8/2023 at so and so resort, Doimung around.
You are not Longkun Tare.
No,
You
no,
are not that person.
I am not that person. I am the one who has been released by this honorable court. I am not named in the FIR.
Okay.
Further, it is pertinent to mention here that they were pre-planned to attack me as some years back, so and so, forcefully making unnecessary allegation that I was having affairs with the wife so and so without any proof, and that is the reason why today they brutally attack me with deadly weapons like iron rods, stones, wooden sticks, and thereafter I was almost unconscious state and found that I got seriously inflicted or injury by the weapons they use, like left side of my ears have fully bitten blood. Bitten up. Well, that the allegation was there that iron rods and all, but then actually the fact is not. There was an altercation between them, and then in the process, the ear was bitten off. There is nothing, no blunt object. And serious head injury, and thereafter
Bitten off
doctor has
means
suggested
It was bitten by
mouth.
teeth or it is removed,
Teeth.
removed,
No, only teeth. By teeth,
just biting.
just by teeth. But just if my lord allow me to make one small statement. It is the offshoot of the decriminalization of section 497 of the IPC. So therefore, it is my humble prayer before a good office to immediate arrest and register the criminal case against mention about criminal and his gang and so.
When they use my ear have been fully bitten off, it implies that it is
Not gone.
biting, it is removed.
Yes, no, that.
Now whether his ear in his place or not.
It is there very much there. It is very much. My lord, kindly see the conduct of this fellow. Kindly come to arrest memo and all this. Kindly come to page 17 for a moment. The reasons and object that I made the statement. This is, my lord, this problem is coupled with the influence of the social media and using it in a negative formula.
What is this? Did come apology letter?
Earlier, the victim complainant was having these kind of things with the main accused wife. And there's
Present petitioner,
no,
the
main one.
Main one, okay.
Yes, Lanku Tarev. Normally, not in this, I don't take the name of the accused and all those.
Okay, okay.
And here is the case, Lord. Kindly see this. I don't want to read it out.
How many days you are behind the bar?
20 since 27.
How many days?
10 days by now.
10.
I am in the judicial custody of since 30th.
And when the main accused was released,
Main on 30 minutes. Kindly see that order.
by which court?
This court.
This court.
This court. Well, for a moment, Milord, Milord, kindly come to para 6 of my bail application for a moment. At page 5. Two small paragraph on the page 4. Kindly come to page 4.
Para?
Para 5.
Yes.
That on receipt of complaint, the officer in charge of Doimung Police Station has registered a criminal case against the alleged accused person, being Doimung PS case number so and so. And I am kneeling for investigation. On 27, the Lord will mark this. After more than 6 days of the incident, IO of the case has called him to appear before the police station Doimung for recording of his statement as witness. I was not involved. Accordingly, the alleged accused person has appeared before the IO of the case at police station Doimung and IO of the case recorded is a statement under 161 CRPC, and pertinently, the alleged accused person was arrested by the IO of the case at around 3:30 PM and accordingly informed the family members of the alleged accused by notice under section 50 so and so on the same day. Since then, Lord. Paragraph 6 will clarify my position, Lord.
This alleged accused means you in
Yes,
para 5,
para 5,
not the main accused.
no the main accused.
Okay.
But Lord will see at para 6. The factual background of the case is that on 28/2022, the so and so of the alleged accused, Mr. So and so, informed the alleged accused person about the incident at 10:35 to 10:40 AM. When he was at home, Anya called him usually over phone. Having received the information, he also informed Mr. Nishtel Miller, that is the accused in another bail application, about the incident. Thereafter, both of them, along with other relatives, immediately rushed towards the place of incident at around 11:30 AM. And on reaching the spot, found the police have already reached the spot after the incident had already taken place between the alleged accused person, Mr. So-and-so, and the victim informant to the police station. Thereafter, the alleged accused person, Mr. So-and-so, along with other relatives of so-and-so, was followed them up to police station. I was very much there. After the incident is occurred, what had happened, the IO who was investigating the matter, for some reasons, anyway, I'm not going to get into that.
Where is the bail order of the main accused?
I have furnished copy.
Or you have just.
Yes.
confirmed that?
That applying the doctrine of parity, on
Yes.
fact.
Whether case diary has arrived. Do you need his detention?
Lordship, detention, lordship, not required lordship, as per this case diary lordship, because they have appeared before the IO and they have submitted a statement. But the lordship, but if lordship is willing to make them absolute, then strict terms and conditions may be applied lordship. Because they are lordship, brutally they have.
No, he's still in jail.
Yeah, I'm in jail,
Lordship,
judicial custody now.
judicial custody lordship.
Judicial custody.
No, sir.
This is a normal,
Just
not the question of making absolute. It is a
lordship.
question of whether to grant bail or not.
Or lordship, because lordship, they have interim protection given lordship. They have to-
No, this is a regular bail.
Regular bail. It is a regular bail.
Lordship, no lordship, I'm sorry lordship, like last occasion lordship, they have come for the lordship in the motion stage. Where lordship, they have paid for the bail, but I have objected that let that their statement be recorded and produce.
Now the
yes,
statement has been recorded.
Lordship,
Okay.
because lordship, and
Let-
one
let-
more accused is lordship, they have
Yet,
been
yet to be.
lordship,
Yet
because
to be
they are
arrested.
lordship, because there are three of them lordship, with
But
the
is there
accused.
any endorsement in the case diary that his detention would
Lordship,
help? No, listen to my query.
lordship.
That whether his detention would help the IO to arrest the other person, how it will help?
Lordship, they think the lordship not reflected,
Not
lordship,
reflected.
not
So
lordship,
his detention is not required.
not lordship, no.
Let him cooperate in the investigation.
Lordship,
That's the small judgment of the parity supreme would like us.
Yes. Heard
Paragraph.
heard Mr. T. Tara, the counsel for the petitioner, also heard Ms. L. Hage, learned additional public prosecutor. This application under section 439 of the Code of Criminal Procedure, 1973, has been filed for seeking bail of the accused Lokam Tafik.
Correct.
The petitioner is someone else.
Petitioner is the brother, younger brother.
Lokam Tafik who has been detained behind the bars since 28, since 20 or 27,
27.
but you have mentioned in your cause title as 20. Is it 20 or 27?
Hello?
Is it 20 or 27?
I was, these two accused were arrested on 27 after
The
6 days.
present petitioner?
Yes,
Now you are for the only one person,
yeah, subsequent bail applications there.
the Lokam Tafik only.
Yes, locum tenens.
Who was arrested, who is detained behind the bar since 27/8/2023 in connection with Doimuk PS case number 46/2023 under section 326/427/34 of the Indian Penal Code. The next para, the accusation in this case is that on 28/2023, one Shri Achi Sorang lodged an FIR before the officer in charge of Doimuk Police Station, inter alia, alleging that on that day he was brutally attacked by Shri Longkung Tare and his associates, causing Longkung Tare and his associates with iron rods, stone, wooden sticks, inflicting serious injuries on his person, and his ears, left side of his ears were also bitten off. On receipt of the said FIR, the Doimuk PS case number 47/2023 was registered. Learned counsel for the petitioner has submitted that you are denying that you are not involved.
I was not involved. In the paragraph 6,
Has submitted that
after the incident, on the
that the
information,
present petitioner, namely the present accused person,
locum takar,
namely Lokam Tapik,
Tak-
Tapik,
tapik, so locum tapik.
Lokam Tapik is no way involved in the offense alleged in the FIR. It is also submitted that he is not the named accused in the FIR, and the main accusation is against one Lokung Tare, who has already been released on bail on
38.
30/8/2023 by this court in bail application number 77/2023. Stop. It is also submitted by learned counsel for the petitioner that since last 10 days, the present petitioner is languishing behind the bar, and his statement under section 161 has also been recorded. And on the ground of parity, and as the main accused has already been released on bail, he is entitled to get bail on the ground of parity.
Right.
On the other hand, Ms. L. Hage, learned additional public prosecutor, submits that
Lordship, I have submission that Lordship, as per the victim statement, Lordship, he clearly stated that with the accused person, two other persons are also there, and they also joined with him and badly beaten by the firewood, Lordship.
learned Ms. L. Hage, learned additional public prosecutor, has produced the case diary of Doimuk PS case number 46/2023, which was called for in connection with this case. She has also submitted that on perusal of the case diary, it appears that there are incriminating materials against the present accused person also, though he was initially not named in the FIR. However, she has also submitted that the statement of the accused,
A victim lawsuit.
statement of the victim
victim- victim
victim
person.
and witnesses have been recorded.
Lawsuit.
And the statement of present accused Lokam Tapik has also been recorded under section 161 CRPC. She has further stated that how many accused are yet to be arrested?
Lordship, now only one accused remaining. Lordship.
One accused is yet to be arrested. You are opposing or
Lordship, for against the Lordship, against the other this one remaining accused, 41A also been served Lordship notice.
one accused is yet to be arrested
Lordship.
and notices under 41A has already been
Issued
served
Lordship,
on the
sir. Lordship.
that accused.
Lordship, on the 5th of this month,
Okay.
Lordship.
Now, what is the submission regarding detention?
Regarding Lordship, in the overall
Cus-
Lordship, the as
Custodial
per.
detention is necessary. You are opposing or not?
No, Lordship, I'm just saying, Lordship, custodial interrogation is not necessary.
Necessary.
Not necessary, because
She
they already.
fairly submits that considering the progress made in the investigation, custodial detention of the present accused does not appear to be necessary for fair completion of the investigation of this case. Considering the submissions made by learned counsel for the parties and considering the materials, and after perusing the materials on record, including the case diary of Doimuk PS case number 46/2023, the accused Lokam Tapik is hereby allowed to go on bail of ₹25,000 with one surety of like amount to the satisfaction of learned Chief Judicial Magistrate. Chief Judicial Magistrate where? UPA. Subject to following conditions. That even after his release on bail, the petitioner shall make himself available before the investigating officer as and when so required for the sake of investigation.
Correct.
During the pendency of the investigation. That the petitioner shall not directly or indirectly make any inducement, threat or promise to any person, including the victim, who may be acquainted with the facts of the case so as to dissuade him or her from disclosing such facts to the investigating officer. Any other condition?
Lordship, he's, this is local Lordship, and it may be Lordship, not, leave the jurisdiction Lordship.
During the pendency of the investigation,
Is that,
the petitioner shall not leave the only during the pendency of the
Lordship.
pendency of the investigation, the petitioner shall not leave the jurisdiction of the
instead of, without the permission of the IO?
Chief Judicial Magistrate.
Well, I think normally it will always be prudent for before the investigating officer.
Investigate.
Yes, that's always prudent, Milord.
Okay.
Because unnecessarily he will come and file
Okay,
application and
Okay,
then go.
yes, unnecessarily, yes. And in court also one work will be increased.
Yes. It is very poor fellow, Milord.
He shall not leave the jurisdiction of the. Which jurisdiction he will not leave?
That Doimuk Police Station.
Doimuk Police Station during the
Council.
pendency of the investigation.
Correct.
Without leave of the investigating officer during pendency of the case. With this above observation, this instant bail application is hereby disposed of. Let the case diary be sent back.
Milord, may I seek
Obliged,
one
Lordship.
mercy? Instead of 25, Milord, can it be 10,000? It's a poor fellow.
You want it to, normally, I used to mention 30.
30,000.
30.
Milord, I'm aware, I have
But
seen it.
here it is, what do you want?
Milord, it's a poor fellow. Even I'm doing pro bono, Milord, just if it can be 10,000.
Okay, let it be 10,000. Instead of 25,000, make it 10,000.
Below the same order in the next item also. Here the accused is Nish Teddy, the applicant is New Raju. Same facts,
Case is same.
same FIR, same fact. And I was also arrested on 27 only, after 6 days of the incident.
Here also you have in cause title mentioned 27 or 20
Below some small
typing mistakes.
typing. I apologize for the mistake. And then while settling the petition, below these days,
So same order will,
Lordship,
yes,
same order change, other facts remain
same.
same lordship.
You are not named in the FIR.
Not named in the FIR. And on after
You are also arrested on 27.
same day, along with this.
Nick, name is Nick Taylor.
Teddy.
Nick Taylor. Only name of the accused will be changed, other condition remains. changed.
Yes.
You are also poor fellow.
Well, it's the same, this villagers, normally in private society, what happens? We are closely knitted, Miller. Suppose if there is an incident happen to one of the.
No, no,
family
regarding the
members.
bail amount,
Yes,
bail amount.
10,000.
Make it 15 lordship, 10 is.
We kindly, Miller.
Let it be same.
Same. Grateful. Miller.
All right, Lord.
My lordship, this matter is compounding of non-compoundable cases. This application has been filed under 482 CRPC. This we have come into the accused under this joint. This is a joint petition, and accused person and the complainant has
We have called for the LCR.
yes
Also received.
also received.
What are the non-compoundable section?
They have come into the negotiation table and mutually resolve the issue. Kindly see, lordship, is
Both are adults. What was the nature of allegation?
nature of the allegation is lordship under section 354A. That is a sexual harassment,
What is,
354A IPC.
Capital.
And
354
354A,
capital A? What is?
capital A, that is sexual harassment, which is non-compoundable in nature.
What is the nature of sexual harassment?
Next,
What you did? What is the allegation against you?
allegation is lordship,
Now
actually,
let
there was
us first of all read 354A.
initially lordship, there is this complainant is a lecturer in a college, private college. And the accused person is his,
In
student.
354A, there are 4 acts, kinds of acts.
only this, rest of the section has been already dropped, and 354A 506 and section 66E of the IT Act that is pending. That is the case.
66E is punishment for cyber terrorism. Punishments up to life imprisonment.
No, that is not the case.
No, no. Section,
Kindness.
section 66E of IT Act. I have the act.
What is
That
that?
is a.
Punishment for cyber terrorism.
What is the definition of cyber?
66E, kindly.
66E.
66E, this is F.
This is E. E na E.
F.
E F E na.
IT?
Oh, picture me. 66E, 66E.
Okay.
66E. That is a breach of privacy.
Oh, punishment for violation of privacy.
IT, information technology,
Yes, IT Act.
violation of privacy.
It is
Violation
printed
of-
wrongly here. 366E.
Your book is, in your book, it is printed wrongly.
Printed wrongly.
It's printed on 2023 only.
So
Published.
additional PP must change his book. Otherwise,
It's required to change. 66.
Immediately you should change that to.
Yes,
Otherwise, the litigants would be in problem.
it is printed 66 E.
As
Two
per
twice.
section 66 is, he may be punished, and extendable up to 3 years. As far as
Okay.
this penal
Now, what
code.
was the allegation? What
Allegation is
what
that,
you did?
this is Genesis law. Genesis, this boy is a student. This accused person is a student who was doing study in the private college where the complainant was working as a lecturer.
Okay,
And this poor fellow, this boy was doing study in her college and also a milkman, a son of a milkman. He was supplying milk to this colony area. And during the course of staying at the college, there was a love affairs between the parties. And
between victim and the,
in between the victim and the boy, because he was two years senior to the complainant victim.
okay,
This accused is 2 years junior to the complainant. Her student. So
but the
as
victim is the teacher.
victim is a teacher,
Okay,
his teacher, and as per the 164 statement given by before the magistrate by the accused person, he has said that kindly see in the page number 30, the magistrate has asked, what do you want to? Page number 30 of the confessional statement of the accused person under 164 CRPC. And page number relevant para is page number 38. 38. This is one relevant question that has been asked by the magistrate concerned during the course of recording of his evidence. Said that, what do you want to confess? He said, accused said, I and the complainant Miss
the
Sangeeta
live
Kishan.
streaming should stop.
I and Miss Sangeeta, this is a complainant.
Authorities in support of his case. The prayer is allowed. Let this case be listed after how much time you,
After 4 weeks.
4 weeks.
4 weeks.
Let this case be listed after 4 weeks accordingly.
Hide up.
None appears for the applicant. None appears for the applicant on call. Let this matter be listed after 1 week. You can appeal. You are ready? Ready for hearing? Others, both sides are ready.
Both sides are ready, Lordship.
So
Because
I
this
may-
is a long pending case, 2019 case, but it is a second appeal only. So
How much time will you require? It will take some time. Before this, before taking up this case, let us finish the other order matters. Or it will not take much
Yes,
time.
yes.
Then we'll take it up.
yes.
My pleasure, Lordship.
Yes.
I was hoping that the matter would be disposed of today. Lordship, I have taken steps upon the respondent too, the informant.
But none has appeared.
Yes, it
With-
seems they are not appearing,
Scan copy. of-
but, and this is not the first time that's been listed after.
Now, whether the service is complete,
Yes, I believe so. It was through the Niti Vihar police station.
when was service complete?
Lordship, sorry.
When it,
Uh,
there is no.
Lordship, by the last order, it was directed to effect the service through,
Okay,
and we had done the needful.
where is the service report of the OC? Find out the. In these. This, there is an office note, next page, next page. Next page. Last. You look into the records. Next page, last note, next page. Then on the. I want the report of the OC. This is the service report in respect of R2 received from the police station. Where is this? What is the matter?
Lordship, charges have been framed against me without any materials, without even a date of offense, Lordship.
You are here for quashing.
Yes,
Huh? Yes, service is complete. Who is the other side? What is name of the other side?
additional PP, I
No,
think.
no, the respondent number 2.
Respondent number 2 is the Director, Urban Development and Housing.
Oh, it has been. Whether additional PP is ready today, or should I?
Lordship, she was here a moment back, I don't know, didn't ask. But Lordship, the problem here is the proceedings were stayed by the last order on 29/3/23, but without even hearing us, on the 16/5/23, the interim was vacated, so now the matter is.
Why interim was vacated?
Lordship, the Honorable Court seemed to be of the opinion that this was not a case in which interim should have been granted. At least that was what was stated before the bar. That matter had came up only for orders on whether the respondent number 2 service has been affected or not. So we were not expecting that kind of order, but the Honorable Court was of the view that this was not a case in which interim stay should have been granted at all. So we have approached the Honorable Supreme Court against that order, but till now it is pending, so we're not expecting any order anytime soon. So we prefer that this matter may be disposed of instead. We are, the petitioner is just a peon.
in secretariat, so he doesn't have much money, so no money, in fact. So we had approached the State Legal Services Authority and they
But
have
the
sent,
stay vacating order is a detailed order.
Lordship,
Stay vacating order. is
yes,
Long order, detailed order.
detailed, Lordship.
It is a detailed order.
It seems so, Lordship, but to be very honest, Lordship, we were not at all hurt that day. But
the-
still,
Observations made therein may go against you.
yes, but Lordship may note one thing. On the date the stay was granted, between the day the stay was granted and the day on which the interim stay was vacated, there were no change of circumstances at all, in the sense that no LCR was received, no respondents had come, Lordship. There was nothing
On
to,
that day you were absent.
yes, Lordship. In fact, my junior was here. I was in court number 1.
Somebody was there.
Yes. So unfortunately, it happened like that.
The state praised for vacating of stay.
No, nobody praised. The Honorable Court was of the opinion that this is not a case in which stay should have been given at all. That was the observation the Honorable Court made in the beginning of the proceeding itself. Since the matter was just for orders on whether or not respondent number 2 had received notice, we were not expecting such order or such hearing would be taken up. And in fact, the LCR had also not come. So there was no change of circumstances at all that would have resulted in such an order. But still, Lordship, that order has been passed. So we have approached the Honorable Supreme Court through legal aid, but they are being very slow in filing the case, and we don't have any other option. In my respectful submission, Lordship, since it was a coordinate bench and there was no change of circumstances, such an order should not have been passed. At least at that point, Lordship.
Now, what do you want? The state is ready for hearing.
Lordship, I am very sorry, Lordship. My file is not traceable, Lordship. They have my staff, Lordship. They have yesterday it was their, Lordship. Now I was searching since morning, Lordship. They have misplaced the file, Lordship. So maybe tomorrow, Lordship.
Tomorrow, okay.
Lordship. Kindly.
Not tomorrow. Tomorrow I want to leave.
I'll try to make it as brief as possible, Lordship. Because there are only 3 witnesses, and the facts are also very, very less. Just 2 lines, Lordship, if your Lordship agrees.
I'm very sorry, Lordship, because
No issue. Let it come up next week before some other judge.
Lordship.
Because tomorrow, if I fix it, if I start hearing it, it may take time. And I don't know whether the RSA would, the second appeal would go how long? Because it is.
I don't know how much time your Lordship would take, but if
And
the matter is taken up, Lordship, I would really not take any time. It will be over within 10 minutes. And there are no facts at all in this case.
is it so?
Yes.
I have
All
not,
lawyers say so. Within
have-
10 minutes.
I've not gone through the Lordship, brief, Lordship. So
If your Lordship, tomorrow it may be taken up. If your Lordship feels that it will take time, then we have no issues getting it fixed next week. But I would try to.
Okay, let it be tomorrow.
Lordship.
Heard. Because tomorrow I have to.
Yes, I
leave
understand,
early.
Lordship.
Heard Miss
And Duncan,
N.
Duncan,
King. Which item number is this?
26.
Heard Miss S. N. King. Learned counsel for the petitioner, also heard Miss L. Hage, learned additional public prosecutor, who submits that, who prays for an adjournment for today on the ground that she is unable to trace out the brief of the case. Considering the grounds mentioned by learned additional public prosecutor, the prayer is allowed. Let this matter be listed tomorrow, that is on 8th of September. For admission, for hearing,
For orders.
not for orders.
Let it be for admission, Lordship.
And what would happen to the,
Services are completed, complete हो गए.
regarding survey, completion of service?
Lordship,
Let it be fixed for others,
obliged,
for admission hearing.
yes. Obliged, Lordship.
And you verify whether order, the notice have been served or not. If you can satisfy the court that we can go ahead with hearing.
Personally, I know that the notice has been served, but
Now what record says.
yes,
Good,
yes. Obliged.
you also go. Tomorrow,
Much obliged.
yes. Now, this case.
RSA 2. First one.
What is the matter?
Gist of the case is that
No, because what I am on that, if I hear it, I have to carry files to Guwahati.
Yeah.
And files seems to be very bulky. There are how many cases?
11.
11 cases. Otherwise, both parties are ready.
Yes.
Yes, Lordship, we are ready
Because,
to provide.
Case will be not so, it will not take so much time. So far, if your lordship decide one case, then it will be decided all the cases. So I'll argue only of one case. And it will cover the entire cases. What happened in this case? We are the defendant in the suit. And plaintiff filed the suit.
Just a minute.
First, I only sum up only.
Now, before you start summing up,
Then I will start from the.
just a minute. It is. RSA 2 along with how many cases? 10 others,
10.
9 others.
Total?
Good.
Total
Total 11.
11.
cases, 10.
10 others.
Mr. S.K. Ghosh for the appellant. Yes. What is the gist?
This is that the plaintiff filed a suit on the ground that they have deposited RD amount we are the postal department. Union of India represented by the postal department. They have deposited money in RD account. And that note I will give later on.
Written.
Only this time saying they have deposited amount in RD. Their claim is that they have deposited amount, but they are not getting refund. And
there was a correspondence. Our claim is that the entire amount was not deposited by the one agent with whom they have opened with the agent, they have opened their postal RD account. Our claim is that the entire amount which they are claiming, it was not deposited in postal department. There are some amount they have deposited. We are
Now, in each case, different account was,
yes in each case.
so why these are tagged together? Because of only the nature, common nature.
Common nature.
Otherwise, the amount is different.
Amount is different.
Date of deposit is different.
Different.
Depositor is different.
Different.
The post offices are same or different?
Same.
The
Only post offices are same.
post office is same.
Same. By same as one agent.
Okay.
So our claim is that this.
Deposited under what scheme? Is
Uh,
there any scheme?
The agent is under the small savings schemes. The agent was appointed.
Through some agent, the deposits were made.
Initially, this department was under the Union of India, but subsequently this department has been taken over by the state government. So when this deposit was made, the agent was under the state government. That part I will come later on. What happens? They deposited. Our claim is that no, they have not deposited entire amount. Whatever admitted amount you deposited, you take away.
So
that money.
then
There was
in each case, your plea would be different.
different.
In each case,
Then suit filed, but though we have filed written statement, but it was an ex parte because it is not in time. In the some of the cases, ex parte vacation order
where
was
the
not,
suit was filed,
suit was filed 2015
where, in which court?
in civil judge senior division, capital complex, UPR.
All cases.
All cases.
All cases in
All
UP.
cases.
And all cases in 2018,
15.
15.
Then it was ex parte. So
Ex parte, it was decreed ex parte,
decreed ex parte.
decreed ex parte.
Now, when it was decreed ex parte, our contention, then we filed appeal. Preferred a first appeal before this district judge,
Okay.
and first appeal was also dismissed.
Dismissed.
This is concurrent finding. But what happened? Our plea before the first appellate court was that it was ex parte decree, so burden entirely lies upon the plaintiff. He will have to prove that whether the amount which he has claimed that has been actually deposited and whether that deposit has been duly proved by the plaintiff before this honorable court or not. That was our plea. But what happened in lower appellate court, what he has done, lower appellate court done that, no, this question, there is no substantial question of law, so suit is, the appeal is dismissed. Only one point. And whether in the first appellate court,
No substantial question of
of
law,
law is required or not.
but here it is required.
Yes. Held it is required. And other on merit, they have not touched at all.
Okay.
So
So what is the substantial question of law in this appeal?
now when it was admitted, at that point of time, one substantial question of law was
Was
framed.
formulated.
Then on by order dated 23/3/2023, another 3 substantial question of law were framed. On first day,
Total 4 substantial.
4 substantial question of law. First substantial question of law is admitted amount,
Live streaming is on. Okay.
whether on the basis of admitted amount, court can grant entire decree entirely, entire decree in absence of admission. That was first substantial question of law.
No question of admission, the
Admission on our, on the pleadings of the record that there was a admitted amount, some amount is admitted, which were deposited with us. Not entire amount. On the basis of that substantial question of law, there was an interim order passed. The let the admitted amount be deposited before this honorable court, and then matter was admitted. We accordingly deposited the admitted amount.
Now that amount is lying with the,
Now, not lying, one, I have gone through record, one respondent has withdrawn and other did not withdraw the amount. Now, on 23/3/2023, three substantial question of law was whether in first appellate court 96(4) CPC is applicable or not. Section 96(4). In 96(4), it says that whether CPC 96(4) is relating to no appeal shall lie except on the question of law from the decree in a suit of the nature of cognizable by court of small causes, when the amount or value of the subject matter of the original suit does not exceed 10,000 rupees. So here all the cases are exceed 10,000 rupees. So this question appears to be in favor of the appellant, because lower appellate court has not, without examining the same, only held that 96(4), by applying 96(4).
you have to give small bullet points, gist of your argument.
I will give. Then next question of law was Order 7, Rule 17. Read with Order 13, Rule 5 CPC. Order 7, Rule 17. Order 7, Rule 17. Got it. Production of shop books, save in so far as it otherwise provided by the Bankers Book Evidence Act, where the document on which the plaintiff sue is an entry in the shop books or other account in his possession or power, the plaintiff shall produce the books of accounts at the time of filing of the plaint, together with copy of the entry on which he relies. So basically their case is on the basis of a passbook, books of account, which they have possessed. And these books of account, my argument will be that at the time of plaintiff sues in entirety in shop books or other account in his possession or power, the plaintiff shall produce the book or account at the time of filing of the plaint, together with copy of the entry on which he relies. This is lacking in this case.
This is lacking.
Now, order.
You mean to say that they have not produced their passbooks?
And they have not only produced, they have not supplied the entire books of to us also when they served the notice. Because
why the suit proceeded ex parte? In the midst of the trial, you
we failed to submit the written statement in time. Subsequently, in some cases, we filed application, but that was rejected. And in some cases, along with the application, written statement was filed. It is on record, but that was not accepted by the court because it is beyond time. Now, regarding Order 13, Rule 5. Order 13, endorsement on copies of admitted entries in book, account and records. Save in so far is otherwise provided by the Bankers Books Evidence Act, where a document admitted in evidence in the suit is an entry in a letter book or shop book or other account in current use. The party on whose behalf the book or account is produced may furnish a copy of the entry. Where such a document is an entry in public record produced from a public officer or by public officer, it is on this context, this substantial question of law.
What was the substantial question?
Whether on the basis, whether following order 7, rule 17 and order 13, rule 5 CBC court can decree the so
Whether
that exactly yes. Order dated 23/3/23. Order dated 23/3/23. And number 3 is mere exhibiting the documents.
number 3 is whether the court below are the law in decreeing the suit of the plaintiff without considering the provision of law that mere exhibiting the document is not proof. Thereafter,
This are the gist of the
and
case.
41 rule, order 41 rule 31,
That is not in conformity with the order 41 rule.
what is order 41 rule 31?
Rule 31, order 41, rule 31, content, date and signature of the judgment of the appellate court shall be in writing, shall state the point for determination, the decision thereon, the reason for decision, where the decree appeal from its revised or varied, the relief to which the appeal is entitled. That means the entire judgment is to be read out. Then it will come to order 41. Rule 31 has been complied or not. After going through the judgment, it will come to whether it has been complied or not.
But that would, is it a substantial question of
Yes, it is a substantial.
whether it has
Yes.
been complied?
Complied, if it is not complied, then it is a substantial question of law.
No. Non-compliance of a requirement of law.
Order 41, rule 31
Yes.
is a substantial question of law. That I will show.
No, non-compliance is a question of fact actually, that
No, but when we will read out the judgment, whether it has been complied or not, then only comes
whether it has been complied
Right
with
or not.
or not.
not.
This is a question of fact. Whether actually it has been complied with or not, this needs factual inquiry. How it can be question of law?
Not factual inquiry from the reading of this judgment. If it is come that the all point has not been decided. If one point is decided, other points has been left out.
Then you have to explain me what is substantial question of law. On that also, because suppose there is a law. That law has not been followed. It is a question of fact or law. There is a law, there is a requirement, procedural requirement under Order 41 Rule 31. That this has to be followed. Points for determination has to be there, reasons for determining. Now, whether it is followed or not, that inquiry is a question of fact or it is a question of law.
My lord,
Question of law perhaps would mean where there is a dispute over law. What is the law? Here, your question has been framed in a way whether it has been followed or not. Now, whether it has been followed or not is a question of fact, which can be gone into by the first appellate court also, whether Order 41, Rule 31 has been followed or not. This may be my question. You have not started, I have also not started. This may be my question which you may have to answer.
yes, yes.
And one more thing. If these 11 cases are clubbed together because there is common question of substantial question of law is involved. If we have to go into facts, whether we have to go into facts or not, which is not permissible in second appeal.
We need not require to go into the facts. From two judgment, I will show. From two judgment, I will show that whether there is any substantial question of law involved or not. First question is, first appellate court, while decided the case on a wrong presumption of law.
Okay, let us meet again after lunch.
Yes.
And we have to decide that whether this hearing can be completed today itself.
May not
or not.
be.
Yes. That clarity has to be there, because I don't have time. If you ensure me that it may be completed today, only then I will go ahead. I am interested because it is an interesting case. Yes. But I'm here only for today and tomorrow.
Lordship, we can complete our hearing, but I think for judgment, Lordship has to, I think.
No, but you have
reserve
to,
or,
hearing also, you may have to give me written notes also.
My lord, written notes today from my part may not be possible because I have come in the
You are
morning.
from Guwahati. also.
Guwahati, yes.
I am come morning, just reached Guwahati. From Guwahati
Because
to,
what happened,
on the
Lordship,
way.
why I am
on the way I.
praying this honorable
told
court
him
to
also.
dispose of this case, because earlier our Lordship Ravin Kumar Pukon, he has already heard. Then later on this 2022, he has, after part had release, after submission of additional issues, substantial,
Not issue,
yes,
substantial
substantial question of law, which my learned brother has placed before this honorable court, Lordship. So this is a long pending, and if we go through the even judgment or fact of the case, it will be shortened our argument because it will not take much time. But while writing the judgment, of course, there is a where each and because not only one person and amounts are different, then date of everything is different. So it may take.
Okay, let us come
Yes,
back.
after.
Then I
If
will
your
raise.
lordship wants, I will shorten the argument. Because I think after going through the only one appellate court judgment.
Okay,
your
I-
lordship
I-
will
No, before, let us first go from the very beginning. Before. Let us come to the substantial question of law which were framed.
Order 41, Rule 30.
Yes.
Order,
What were the substantial question of law which were framed by this court?
Ah.
On which date it was framed?
on first day when it was admitted,
Date?
date. It is in 2019,
23/9.
23/9/2019.
Nine. Yes.
What substantial question of law?
Whether on the basis of admitted.
Yes, please read. Whether the learned court below heard in law while declaring the suit
Of the plaintiff,
For
an
an
amount of so and so without considering exhibit P11. What is P11?
one document,
on application.
What is P11?
they have filed one application, the amount which admitted may be released.
Without considering P11 in absence of admissible proof of such amount being deposited by no. Why I want to, whether the framing of substantial question of law is okay or not. Then we will proceed. Yes. Because this is not a first appeal. Though this is appellate forum, this is a second appeal where we have to confine ourselves only to the substantial question of law.
Yes.
If the question framed is not of substantial question of law, perhaps we can reframe it. So, is this the question which has to be decided? Yes.
First question is, gist of the question is that whether on the basis of admitted document, can learned lower trial court decree the suit in entirety without considering the said document, that is the originally it is a perversity.
Whether on the basis of admitted document,
Can the learned trial court decree the suit in entirety?
beyond what is admitted.
My lord,
Beyond what is admitted.
beyond what is admitted, yes. Number two question, it will,
When it was framed, number two.
number two on 23/3/23. Not number two, there are so many questions on that day. 23/3/23.
No, Lordship, 2nd October, 2nd August 2022. That is
Question.
order dated
Yes, second
Second,
August
yes.
2020.
where additional substantial question of.
No, no. It, actually, it was framed on 23/3/23.
But what is 2nd August?
2nd August, on that day, I submitted the substantial question of law. And on this, senior advocate submits that they may be given an opportunity of being heard before formulating the aforesaid substantial question of law.
Okay. Thereafter,
Thereafter, it was framed on 23/3/23.
why the necessity was felt? Because the earlier question was not found to be appropriate.
Yes.
Why additional?
I have filed a such application.
No, my query is when on 23/9/2019, a substantial question of law was framed. What was the necessity of framing additional?
During course of hearing, it is found that this question also required to be decided.
In addition to what was
In
framed?
addition to the first.
Or
question.
what earlier was framed was not found?
No,
That was,
in addition. In addition.
whether the
learned lower appellate court erred in law in dismissing the appeal by applying the provision of section 96(4) of the Code of Civil Procedure.
okay, it is over. Next,
Next, whether the learned trial court erred in law in declaring the suit of the plaintiff without following provision of Order 7, Rule 17, read with Order 13, Rule 5 of the Code of Civil Procedure.
Order 7, Rule 17, you have read,
Yes.
that relates to books of account,
Yes.
Books.
passbook,
Passbook, etc.
and Order 13, Rule 5.
Is it is endorsement on copies of admitted entries in books, accounts, and records.
No, what it says, what Order 13, Rule 5 says. What
Say-
was not complied, I want to understand.
What was not complied?
What was-
Then, my lord,
Or will you come one by one?
I'll come one by one because why it has not been complied?
Because you have to address me on each substantial question of law one by one.
Kindly see, then I will have to show the plaint for this
Okay,
question.
before that, third question was,
Whether the learned court below erred in law in declaring the suit of the plaintiff without considering the provision of law that mere exhibiting a document is not a proof of the same. First question will, second and third question is related. Suppose somebody has come and came to witness box, this is my document. Without proving the contents of the documents, he produced the document and it has been taken into exhibit, and on the basis of that exhibit, court passed the decree. That is the question where on the basis of mere proving of a document or mere producing a document is the proof of that contents of that document. In respect to third question, I will show the judgment also of various court, including our High Court. That mere exhibiting a document is not the proof of that document.
okay, what was the fourth?
Fourth question is Order 41, Rule 31 in non-compliance in passing affirming the
Order 41, Rule 31 says that the judgment must contain,
all these things.
and that was not there.
Now, whether it is a substantial question of law or not, it is the case of Santosh Hazre's case,
Now you under
2001 3 SCC 179.
2001,
3 SCC 179. And followed by that subsequent judgment I have brought
179 Santosh.
Santosh Hazre.
What it says.
Uh, Santosh Hazri versus Purushottam Tiwari. 2001 3 SCC 179. And another judgment followed by that Santosh Hazre. This judgment I'll hand over. This is not reported judgment. I'll hand over the one copy to other side and to the court also. Paragraph 8 can be seen. From paragraph 7, Santosh Hazra has been quoted in paragraph 7 in the judgment. And paragraph 8
This is not a reported judgment.
not reported judgment. This Supreme Court judgment. Here in this case, it is in the case in hand, High Court has not referred to even an iota of evidence which was adduced by the parties. There were large number of landlords whose land was acquired and they have filed separate objection under section 9 of the Act and had separately sought reference under section 17 of the Act. They had separately laid evidence in support of their cases before the reference court. It is not a case where a single case may have been large number of parties and evidence adduced in common for all of them. In the matter of determination of compensation, large number of factors have to be seen, namely nature and quality of land, whether irrigated or unirrigated facilities for irrigated like existence of well, etc., presence of fruit bearing trees, the location of the land, closeness to the road of highway evidence. Next is namely so and so whether it gets next para. The High Court has not at all averred to even a single piece of evidence, and there is absolutely no indication in the judgment as to how it has come to conclusion that finding recorded by the reference court required to be affirmed. There being total non-compliance of mandatory provision of Order 41 Rule 31 CPC, we have no option but to set aside the judgment of the High Court and remanded the matter to the High Court for fresh consideration of the appeal. It is followed by actually Santosh Hazre's case.
This appeal under Supreme Court was under what? Is it a second appeal?
Yes, yes, because the first appeal was before the High Court.
Now, how we will come to know whether section 100 is applicable in this appeal or not?
Then, my lord, in Santosh Hazre's case, all the points has been considered.
Come to Santosh Hazre.
My lord,
Where is Santosh Hazre's case?
their judgment today, actually I have brought, but Well, at that point I will come later on, because if we succeed in other points,
No, first you have to succeed in
no,
question that I'll be confining only to
Question.
substantial question.
yes, I am confining to substantial question.
Unless you convince me that this is a substantial question of law.
Yes,
In the second appeal, I'll not go into that.
this is regarding 96(4) has been, by applying 96(4), whether the first appellate court can dismiss my appeal.
That is a substantial question.
That I will show.
But where,
And-
that is number one.
Yes, that I will show. That I will show. Kindly see the appellate court judgment.
Before that, you have to explain what is a substantial question of law.
The substantial question of law is the question
Santosh,
which,
Santosh Hajre explains it.
my lord, on the context of order 41, rule 31.
Only on the context of.
On the context, in non considering other part. What would be the cause to the, because suppose in the first appellate court, it has been affirmed. Here in this case, the first appellate court affirmed the judgment of the trial court. So when it is affirmed, it ought to have been dealt with all the points.
That is a substantial question.
That is the order 41, rule 31. All the points, all the evidence, as well as all the points which has been raised in the first appellate court, that is to be re-examined, or evidence which has been taken into consideration, that to be considered on record. I am here in this case, I have not laid any evidence. I have not, even my written statement was also not accepted. Here in this case, only on the basis of plaintiff's case, I will have to show that whether the plaintiffs has able to prove their case or not. If the plaintiff is able to prove their case, then I am out.
Yes, continue.
Now regarding first point, 96.
No, what I wanted actually. Initially, I'm putting these questions because you have to tell me that this is your jurisdiction within section 100 or while exercising second appellate power of the second appellate court. This is your jurisdiction. And these questions I have raised, and this you have to decide. There is a tendency of raising questions which ought to have been raised in first appeal before second appellate court. So on that, I want clarity that in exercise of power under section 100, beyond this court need not to go. And therefore, the question of formulation of substantial question of law is important. Suppose the questions are formulated in a way that it appears that these are question of fact only. After hearing you later on, after going through record, I come to an opinion that these are a question of fact only. Then there would be no one to help me. You will be not before me. Therefore, I am raising this. I am making things clearer to you that you have to make things more clearer to me while making your submissions. That this is what section 100's jurisdiction. Within this, you have to limit your submissions.
Yes, yes. The point which has been raised, my lord, on the basis, I will confine only on that. I will not go the beyond that.
Okay.
I will not go beyond.
Yes, continue.
Now regarding 96(4). (96)(4). Kindly see the lower appellate court judgment.
At page,
Start from page 71.
yes.
From page 71 to 84 is the fact.
Yes.
I'll, because I am answering one by one, that is fact. I am at this stage, I am not reading. I am only confined to 96(4). Page 84. Point for determination. Whether the appellant can raise, also got it, 84.
Yes.
Whether the appellant can raise new ground of defense in the appellate court, which were not raised before the original court. In this regard, my answer is it can be raised because first appellate court being the last court of law and fact. So it can be raised at the first appellate stage also. And more so when we have the case proceeded ex parte against the appellant. Now, next question, whether the appellant raised any substantial question of law before the appellate court as provided under section 96(4) of CPC. My answer to this question is not at all applicable in the case of the first appeal. Because first appellate court being the last court of law and fact. So this question is also not maintainable. And next question, whether the learned court of civil judge, senior division UPR was justified in passing the impugned judgment and decree order dated so and so in money suit number so and so. So this is the question is to be determined by the learned lower appellate court. Now, next, page 85. Argument and submission by the learned counsel. On 19/3/99, all the learned counsel made the final hearing, reiterating the facts stated their claims. In this case, I have submitted. I have personally appeared, but my submission has not been recorded.
In appeal,
I personally appeared. I submitted. He is also in the that side, other side. Now, findings and reason for decision. After hearing all the learned counsels, the court perused the LCR of the so and found that by order dated 9/9/2015, it reflects that the defendant number 1, 2, and 3 made their appearance on 2/4.
what the first appellate court meant when it says that on 19/3/19, all learned counsels made final hearing reiterating their
Yes,
facts stated in their plain,
plain.
only plain. You have to answer it.
That answer,
Take a note. So you also reiterated what is stated in plain.
my lord. I have submitted on the basis of my the appeal. As well, all the point which I am now raising also. That point also I have raised, that although it was an
Mention is only about the plain.
explain,
Okay.
although I appeared and said that being the first appellate court, being the last court of law and fact. So I confined to the plain, I have to confine to the plain as because I have not laid evidence, my written statement was not accepted. But when we confine to the plain, we must cautious that when decree is to be passed on the ex parte decree, the evidence which has been laid is to be more cautious than the decided if contested case. But all these things has not been recorded. That point was raised by me that evidence is to be considered first. Only plaintiff's evidence, not my evidence. On the basis of the plaintiff's evidence, whether this suit can be decreed in entirety. And whether the evidence which has been laid, that is an admissible evidence or not. All this point has not been discussed, whatever it is, but now we are in second appeal, my lord. I cannot blame on the court also at the same time. Finding and reason decisions. After hearing all learned counsel, the court perused the LCR and the learned court civil judge UPA and found that by order dated 9/9/2015, it is reflected that defendant number 1, 2, 3 made their appearance on 2/4/2015, but for more than 90 days as a permission under order 8 of CPC did not file the written statement and continuously remain absent without any step. So suit proceeded ex parte against defendant number 1, 2, 3, and 6. Further, in order dated 12/10/2015, learned civil judge senior division UPA stated that the suit proceeded ex parte against defendant number 1, 2, 3, 5, and 6. However, by order dated so and so, in between the typed order, it is written in handwriting that defendant number 1, 2, 3 had filed WS, but the PO is reported to be on leave on that day, and against the signature of presiding officer, someone else's signature is there. And nowhere in the order sheet it has been reflected that ex parte order was ever vacated or prayed to be vacated. Also, its subsequent order sheet, the appearance of defendant number 1, 2, 3, 5, 6 are not reflected during the time of examination of witness. Further, it has been reflected in para 2 of the judgment and order dated so and so that defendant number so and so, Chief Postmaster General, Sub Postmaster so and so, and Union of India did not appear in the suit for contesting the case. Hence, by order dated, the present case proceeded ex parte against them. So it is confirmed that appellate court who were defendant number 1, 2, 3 in the money suit did not file their written statement nor contested the case. Further, they never prayed for vacate the ex parte order despite of having knowledge about the case pending against them. Therefore, the first point for consideration, it is decided that appellant cannot raise new ground of defense in the appellate court. This is regarding first question with determination of question, which were not raised before the original court. So my submission, this finding is not at all correct finding, because being the last court of law and fact, we can raise all this issue. Even if it is an ex parte order can be challenged either for vacation of ex parte order or by way of filing appeal. In this case, we have filed an appeal. Without resorting the provision of order 9 rule 30, we have provided first appeal. Further, as the appellant did not raise any objection to file their written statement before the trial court, despite the knowing the pendency of the case, So under orders 8 rule 5 CPC, it can be assumed that the defendant appellant had admitted to the statement made by the plaintiff in the money suit. Also, order 8 rule 5 states that where the defendant has not filed a pleading, it shall be lawful for the court to pronounce judgment on the basis of fact contained in the plaint. This is also a wrong finding.
Why?
Because on the basis, suit cannot be decreed only basis of on the plaint. There must be some evidence is to be laid by the plaintiff, admissible evidence, not inadmissible evidence. That judgment I will show, not only on the basis of plaint, it should be on the basis of plaint and evidence. Answering the second point for determination, it is found that the whole appeal petition appellant has not raised any substantial question of law as provided under order 96 rule 4.
What is read order 96 rule 4?
CPC.
Where is this CPC?
This order 96
It is section 96 rule.
rule 4 has been incorporated in the year after amendment of 1976. No appeal shall lie.
Yes, read it.
No appeal shall lie except on a question of law from a decree in any suit of the nature of cognizable by code of small causes, where the amount or value of the suit subject matter of the original suit does not exceed 10,000 rupees.
So your answer is as it is not a decree,
By either by small causes
small causes.
or by less than 10,000.
Less than 10%. Therefore, order 96 rule 4 is
Is not applicable. Now, nowhere the appellate could prove that learned lower court has violated any procedure of law while passing the impugn order. It has simply tried to shift the burden of liabilities on the other defendants, which they never raised before the lower court. Hence, the second point for determination is also answered in negative, and the appellate seems to have failed, having raised any substantial question of law under order 96 rule 4 CPC. Further, section 96 4 CPC clearly stated that no appeal shall lie except on a question of law. Other part has been omitted.
Okay. So your submission is clear.
Clear.
That 96(4) is not applicable. So on that count, first appellate court was wrong as
Wrong.
per your submission.
And other point has not been decided. Next page, can you see? The main question, main point, the point for determination number 3 has not been decided. That was the main determination question for the purpose of deciding the first appeal. May I read that question?
Yeah.
Page 84, whether the learned Court of Civil Justice Senior Division UPA was justified in passing impugn judgment and decree order dated so and so in manuscript number so and so.
That was decided in point 9. Para 9. There is an observation.
My lord, my submission that it is not an decision. For the above mentioned discussion, third point determination
She
to
has
answer.
stated that she has discussed
Point number 2,
in foregoing paragraph.
yes. Foregoing paragraphs is the
Suppose 90, para 8 is deleted. Then she states that she has discussed in para 2 to para 7
para 7 decided that on the basis of plain.
on the basis of plain.
Plain. And we have another has been said that I have no right to raise any new point in the first appellate court.
Yes.
So first point that regarding on the basis of plaint is not maintainable. My lord, one judgment I am relying 2004 3 GLR 284.
Three GLR
248.
248. The
Para 7.
parties are
Party's name, my lord, Shukdev Rai versus Ashok Kumar Rai. Para 7.
what it says.
Even if a suit proceeded ex parte and in
You
absence
will
of.
provide me a copy.
Yes, I'll.
Ah.
Even if suit proceeded ex parte, in absence of written statement, unless the applicability of order 8 to 10 of CPC is attracted and
Order it rule, admission decree,
order 8 rule 10,
what it says. Decree on admission.
procedure when party fails to present written statement called for by the court. Where party from whom written statement is required under order 1 rule 9 fails to present the same within time permit fixed by the court, as the case may be, court shall pronounce judgment against him or make such an order in relation to the suit as it think fit, and the pronouncement of such judgment a decree shall be drawn up. Order 7 rule, order 8 rule 10 of CPC is attracted and the court acts thereunder. Here in this court did not act thereunder. So plain file, written statement not filed, so decree. That is not. Here in this case, they have laid evidence also. The necessity of proof by the plaintiff of his case to satisfy of the court cannot be dispensed with. In the absence of denial of claim, abandonment, and burden of proof on the plaintiff is not very heavy, a prima facie proof of the relevant fact constituting the cause of action would suffice, and court would grant the plaintiff such relief as to which he may in law be found entitled. In the case which has proceeded ex parte, the court is not bound to frame issue under order 14 and deliver the judgment on every issue as required under order 22 rule 5. Yet the trial court should scrutinize the available pleading and documents. Lordship, available pleadings and documents considered the evidence adduced
Yes.
and would do well to frame the point for determination and proceed to the construct the expertise judgment dealing with the point at issue one by one. Merely because the defendant is absent, the court shall not admit evidence the admissibility. This is my another question also is there. Merely because the defendant is absent, the court shall not admit evidence the admissibility whereof is excluded by law, not permits his decision being influenced by irrelevant or inadmissible evidence. As the judgment in this present case has not pronounced, it is will therefore be necessary for the trial court to now proceed in accordance with the law laid down. That is ultimately remanded. Yes. I hand over this.
Why are you relying this?
I am relying because the trial court declared the suit on the basis of their claim and
Evidence.
the evidence they have submitted. Now, what happened in the plain when they have submitted the plain? Kindly see, look into the NCR Pustak. Plain, kindly see the plain. What documents they have relied at the time of filing of the trial court or second file. Oh. This is their plain. This is, can you see, page 14 and 15.
Here,
Page 14 and 15 of the plaint. Lordship, this is their plaint. Because I am my argument only on the basis of their case.
yes.
Page 14, there is an entry. Because on the basis of this entry, they are claiming 90, next page can we see 9,000, 9,000, 9,000. This is only document. So if we go through this document, 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16. 16 entries has been, they have been supplied in the court as well as to us. Now, on the basis of this relying documents, what they have adduced in evidence. Now I will show the evidence, what they have adduced. This is the book they have, original. Now they brought up with the new. Now whether this document is then admitted in evidence or not. Because all the entries mentioned in the original books of account, books, whatever entries, it is disputed entry, but as we have not filed any written statement, so I am not questioning. I am questioning that the document which they have supplied and in the evidence they have brought us, whether it is permissible. That is why the question order 7, rule 17. Next question, that is why.
No, your submission is that in the plaint at page 14,
Not only plain, in the evidence also. When they have been put in cross-examination, they have brought this document. Kindly see the next page, next photocopy. With the plaint, they have submitted these 2 papers along with this evidence also. Others entry they have not produced. Now, whether it is an admissible under the Indian Evidence Act or not. That judgment I will brought, whether mere exhibiting or mere submitting a document can be a proof of document or not.
I'm not getting your point. This point, in the plaint, they have at page 14,
And 15.
15, they have annexed photocopies of the passbook,
Not entire, some
pages of,
pages only.
but in the evidence, they have exhibited the
No,
entire.
when they submitted evidence, there also they have some document, some pages of documents. But when they have been cross-examined, they have brought this original and produced the court.
When, who exhibited it during cross-examination?
That is cross-examination part, when others defendant was contested.
When a witness is cross-examined, you cross,
We have not cross-examined. Cross-examined by the state also party.
they cross-examine.
Cross-examined.
Then who exhibited?
The plaintiff exhibited. Plaintiff brought this
There
document.
was re-examination.
No,
Then when, how plaintiff examined?
that is still lacking in this case. How it has
See,
come into the
plaintiff
record.
has filed the deposition, the affidavit form, and during that time, all the documents were exhibited before cross-examination.
Oh, you filed on
Yeah,
affidavit.
deposition, yes. Evidence is there, but my learned brother.
Because
whether-
here I will not go into facts. Facts have to be
Yes.
undisputed facts.
Yes.
No, I am not, it is undisputed because plaint I have shown. Plaint I have shown. Evidence of,
No, the submission is that these exhibited documents were filed along with the evidence on affidavit.
that may be whether it is mere filing or mere producing a exhibit.
No, they have
It is a
exhibited
proof.
it. Their submission is, they have exhibited it. Now, what is your submission?
My submission, it is, though it is exhibited or though it has been produced, it is not it is not as per procedure established under the Indian Evidence Act. It has been proved. It has not been proved. This book has not been proved. The contents of the documents has not been proved. This is my submission.
That means someone was contesting also, apart from this.
Yes,
Some witnesses were,
contesting, also.
some but defendants were contesting.
Contesting
defendants.
dependence of yes.
Okay, but the decree is against you.
Yes,
Not against the contesting dependent.
not against.
Who was? who
No,
is-
not against the contesting, there are, as against agent also. Jointly and severally. Contesting was small savings, that is state government. Defendant number. Defendant number. Defendant number 6. 4 and 6. Oh, no, not 4, only 6. 6. Two also. 2 is, oh, yes, 2 also. 2 is the state of Arunachal Pradesh. 2 and 6. Now regarding first substantial question of law, which was made at the time of admission, that document I will show. On the basis of that document, whether the suit can be decreed in entirety. Exhibit 11. Next are 11.
Is this?
I'm ready. To the Director Postal Service, Arunachal Pradesh, so and so dated 3rd November 2014. Subject: immediate release my genuine lordship. Got it.
Yes.
Immediate release my genuine recurring deposit amount of rupees 99,000. Genuine recurring deposit. Along with the admissible interest within 2 weeks, which deposit in my account number. Letter, reference letter. In reference to above subject cited above, I beg to inform you that after going through the contents of your letter dated 26/9/2014, which is reply to my pleader notice, it is learned that Department of Postal Arunachal Pradesh is ready and to refund genuine recurring deposit amount of rupees so and so, along with admissible interest to me, which is lying in the department. Therefore, request you kindly release the amount along with the interest which I am entitled as per provision of law within 2 weeks without fail, otherwise it will cause irreparable loss and injury to me, enclosed copy of so and so. On the basis of this, whether entire suit can be decreed.
No, this is a letter
Written
by
by
the plaintiff.
plaintiff to us.
Okay, then
This is the admissible amount. So on beyond that, court decreed whether it is permissible. Now, what was the decree?
now whether court decreed on the basis of this, on what basis you are saying?
My basis is that even if the court ought to have been decreed, the court ought to have been decreed only this amount only, not beyond that. This is an admissible.
Why, where
amount.
is the reasoning of the trial court?
Nothing. Now kindly see the trial court judgment. This is their document. I have not, we have not produced.
Okay, at the,
Now kindly see the trial court judgment. Page 59. Page 59 in the plain, in our memo paper. The money suit is filed by the plaintiff Tipu Kamchan claiming for realization of rupees 5,11,000 so and so on calculation up to 18/8/2014 plus further interest and cost of the suit till full and final realization of the suit amount on account of money deposited with the defendant by way of recurring deposit scheme. Plaintiff has taken registered steps upon the defendant through prepaid registered post to its correct address. The acknowledgement due card is returned after service upon the defendant, but the defendant number 1, 3, 4, 5, and 7 have not appeared in the present suit for contesting the same. Hence, while order dated, the present case was proceeded expert against them. However, defendant number 2 and 6 has appeared in the present suit for contesting the same, and the case was fixed for hearing.
yes,
During hearing, the case of the plaintiff has examined only one witnesses in support of its case and exhibited as many as 14 documents as exhibits in support of the claim of the plaintiff. The case of the plaintiff is that plaintiff has opened a recurring deposit account on 18 March 2010 at sub post office for RK Mission Itanagar with monthly deposit of so and so for a period of 5 years. The defendant number 5, after receipt of rupees 9,000 in cash, along with the present form duly filed, has issued passbook bearing number so and so. That the recurring deposit scheme account was opened through duly licensed agent, namely Bina Rai, so and so agent under RK Mission Post Office, Itanagar, on 18 March 2010. Who is the defendant number 7 of the instant case, and since then the plaintiff deposited rupees 9,000 each and every month without fail. The amount was deposited through the said agent, and passbook was duly stamped with round seal and signed by the postal stall, who acknowledged the cash money. Thereafter, the passbook was handed over to the plaintiff. Plaintiff deposit of rupees 9,000 each and every month till 29th August 2013. The total amount money deposit was 3,78,000 for a period of 41 months without fail. The defendant number 5, who is the sub postmaster, after receipt of cash money from the client made entry in her passbook each and every month, thereafter put seal and signature. As per the record entry made in the passbook, an amount of rupees 3,78,000 has been deposited in the sub-post so and so. In the month of September 2013, the plaintiff has personally went to RK Mission Post Office, Itanagar, to deposit his monthly recurring amount of rupees so and so, but the postal staff refused to accept her monthly deposit, informing that the higher authority has directed not to accept the deposit. And further inquiry, the plaintiff has been informed that Srimati Bina Rai, agent attached to RK Mission Post Office, Itanagar, collected the recurring deposit of monthly amount from the plaintiff as well as from other depositor and made irregular deposit and misappropriated the same amount. Thereafter, she had fled away from Itanagar. When the plaintiff approached the Postmaster RK Mission Itanagar and other defendants and request to release this recurring deposit amount along with the accrued interest, but failed to release her amount and having not other order remedy was left out, then to file instant suit. The plaintiff, in spite of repeated approach, the defendant has not released the recurring deposit along with the accrued interest. Hence, the plaintiff has issued several notices to the defendant as per the provision of so and so, so and so. It is pleaded that defendants are liable to responsible to liquidate the deposit amount to the plaintiff on the strength of the document passbook with proper seal and entry made by the agent at the time of deposit of the money by the plaintiff. However, the defendant, in spite of being aware as to their lawful obligation, intentionally remain default and neglected in liquidating the recurring deposit. In result, at present as on date 29/8/2013, their accrued outstanding amount of rupees 3,78,000 only as per statement of recurring deposit account calculated by the plaintiff. Hence, the plaintiff has filed the present suit for realization of outstanding loan amount. Defendant number 2 and 6 have appeared in the present suit and has filed written statement in defense of the present case. The case of the defendant number 2 and 3 is the defendant denies each and every statement allegation made against them in the instant suit. The defendants further deny the statements which are inconsistent with contrary to the bond out of record. Further, it has also pleaded that the defendant number 7, Bina Rai, was appointed by MTKBS agency by the Regional Director, National Savings Institute, Guwahati government, by letter dated 97, that at relevant point of time, the appointing authority of MBKS was vested with the Government of India. Therefore, keeping in view of that date of appointment of Bina Rai, it is hereby clarified that Director of Small Savings was not appointing authority as he was directly appointed by the Government of India. Then by order dated so and so, the power of appointment MK so and so was delegated to the Director of Small Savings, Government of Arunachal Pradesh. Thus, Director of Small Savings was not the appointing authority of the defendant number 7. However, her agency license was renewed by the Director of Small Savings basing on the relevant report submitted by the defendant number 7, along with the agency license, which was already issued by the National Savings Institute, Guwahati government of India. As such, defendant number 5 to 6 are not liable in the instant case. Inasmuch as Srimati so was not formally appointed by the Director of Small Savings, Government of Arunachal Pradesh. After completion of pleading of both the parties and after hearing the learned counsel, both the following issues were framed for determination for coming into definite conclusion of the present suit. Whether the defendant number 1, 3, 4, 5 are liable to return the monthly recurring deposit along with the accrued interest to the plaintiff, which has been collected by their duty license authorized agent. Whether the plaintiff is entitled to get a decree of rupees so and so, whether the plaintiff is entitled to get further interest so and so. Now let us discuss the issue one by one coming to the so and so. Got it. Now, para 12. This is the only discussion. Point for determination of issue number 1 and 2. Whether the defendant number 1, 3, 4, and 5 are liable to return monthly recurring deposit along with interest of the claim which has been collected by their duly licensed authorization, and whether the plaintiff is entitled to get a degree of so being the monthly so. For convenience and brevity, issue number 1 and 2 are taken together for discussion and decision. PW1, P2 concern plaintiff has exhibited the recurring deposit passbook issued by the defendant. The defendant has not denied the fact of opening bank account by the plaintiff in RK Mission Post Office. During cross-examination also, the defendant number 2 to 6 have not put any question regarding not opening of recurring deposit in the post office. The other defendant have remained absent during entire trial and has not appeared for cross-examination of the plaintiff and its witness. I have perused the passbook and other corresponding between the plaintiff, other correspondings. Not sure what it is. Yes. Other correspondings between the plaintiff and the defendant, and found that plaintiff has opened the recurring deposit amount for 5 years in so and so economic and deposit amount of rupees so and so. So only decision has been taken whether it has been opened the account with the post office or not, and that part is admitted that he has opened the account. That we are also not denying that he has not opened the account. And so far is liability is concerned, that part has been missing in the entire judgment, that on what basis the entire suit that is decision has been arrived. Next point, can you see?
Next one.
Next point. Page 8. Point for determination.
The
Next point.
first point was determined that I have perused the passbook
Yes,
and correspondence so and so between the
that it was open.
opened for 5 years and deposited an amount of rupees 9,000 at the rate of 8% for 41 months.
Yes,
That was the observation.
that was the observation. That was the observation. Now, point for determination number 3, whether the plaintiff is entitled to get further interest at 2018 per month. Mr. Tipu Kamchan, who is the plaintiff, has exhibited the recurring deposit passbook account number so and so, and also remained issued for payment of recurring deposit amount 9,000 for 41 months along with interest, 8% on several occasions, but the defendant has failed to make the payment. Thereafter, the plaintiff has issued notice so and so defendant, but defendant have failed to repay the outstanding due to the plaintiff. The plaintiff has exhibited the statement of account till 29/8/2030, showing an outstanding due of rupees 3,78,000 in the recurring deposit amount account of the defendant. The said statement is up to 29/8/2013, and the present suit is filed by the plaintiff on 12/5/2015. An outstanding amount of rupees so and so only is claimed by the plaintiff. I have perused the entire document exhibited by the plaintiff in support of the claim. I have no reason to disbelieve the said document and the evidence of the plaintiff witnesses. The statement of the account, that is recurring deposit passbook, reveals that plaintiff has deposited an amount of rupees 3,78,000 in an account on so and so. The defendant have failed to repay the deposit amount to the plaintiff. As such, I am considered opinion that since defendants are financial organization and there is an agreed rate of interest, the plaintiff is also entitled to recover an amount of rupees 3,78,000 from the defendant, specifically defendant number 3, 4, 5, and 7, including the interest at the rate of rupees 8,000 per annum upon the same from 12/5/2015 till realization of the same. Decision. The point for determination 3 is decided in positive and in favor of the plaintiff. It is held that plaintiff is entitled to recover an amount of rupees 3,78,000 only from the defendant number 3, 4, 5, 7 with interest 8% from so and so till realization of the amount. In view of the discussion made above and decision reached in the foregoing paragraph, the present suit is decreed in favor of the plaintiff. Plaintiff is entitled to recover amount of rupees so and so only from the defendant with interest 8% per annum thereon so and so that the date of institution of the suit till realization.
How does the trial court erred in not following order 7 rule 17 and 13 order 13 rule 5?
Yes. My lord, that is why I have shown the plaint. In the plaint, they have not produced all the entries. They have not produced all the entries. And only the passbook has been exhibited. Now, if we consider that it is the passbook, but at the time of filing of the suit, it was not available.
So finally is page 67. Page 67
Of the
of the appeal. 67 of the appeal.
yes.
Here the
list of
document
exhibits.
which was filed along with the plaint was exhibited. And this is the part of judgment.
That is why I have shown the plaint, my lord.
Oh,
That is
but
why I have shown the plaint.
the other is submitted that during time of filing the plaint, it was not filed along with the plaint. That's why I'm showing this exhibit document.
No,
So at the time of filing the plaint, the plaintiff was filed along with all documents.
that is why
And
I
during trial, it was exhibited. So accordingly, the learned trial court below has marked as an exhibit.
my lord, I have shown the plaint. I have not saying that it was not filed. I am saying that only some entries has been filed, not entire. I have not said that it has not been filed.
You have a photocopy of the substantial question of law framed by this court. Do you have an extra copy?
No.
Handy copy? Otherwise, I have to photocopy machine.
No, Lordship, I don't have, but what
He pays to photocopy Korean. Page 25. Delegate the file from a separate file, sorry. There are many appeals. 10 appeals are there now.
11 appeals.
11 appeals.
Yes.
In every appeal, there are same pages.
Yes.
So get this page number 25 photocopy from one. Or you give me, no. Actually, I am getting difficulty in turning around pages of this. Or you give me another appeal. Take out page 25. Not on, yes, order sheet.
I have got a copy, but
No.
without signature, so.
I have found.
Considers.
Get a copy of. You can get it photocopy. This page. We have photocopy machine. Yes. Only the substantial questions of law. Yes.
So first substantial question of law which was framed at the time of admission, I have shown that regarding Annex 13, which is exhibited by them, that was not taken into consideration while this was decreed.
No, I'm not getting regarding annexure 13. Repeat.
11. Annexure
11.
11. Annexure 11 has not been taken into consideration.
Annexure 11 is exhibit 1. No.
No,
Yes, exhibit 1, no, sorry, no, not exhibit 1.
not exhibit 1.
That is
What is annexure 11?
exhibit 10.
What is exhibit 10?
10 is the immediate release my genuine recurring deposit.
Okay,
That,
understood.
that
Admitted
application.
amount.
Admitted amount.
Yeah,
Which the amount which is stated to be admitted.
Yes,
Now, what is your submission? This annexure 11?
has not been taken into consideration while the decree was passed.
No, decree was passed on the basis of exhibited document. When we have gone through the judgment of the
Decree
trial
was passed basically on the basis of exhibit 1, that is passbook, which was produced at the time of evidence, but not produced along with the plaint as well as.
that is your submission.
Yes,
That exhibit 1 was not produced at the time of filing of the plaint.
document, entire
Entire exhibit, entire passbook was not produced.
entire photocopy of passbook.
Therefore, there was violation of the first substantial question of law.
No, not
The first additional.
additional second, order 7, rule 17.
Therefore, there was
Therefore, the
violation.
decree is vitiated.
Now, while looking into the fact that whether it was exhibited or whether it was not exhibited, are we not going into question of facts?
No, I am not saying question of fact. I am saying mere exhibiting only produces before the court. Mere exhibiting without following the procedure or without proving the contents of that exhibit. Without proving the contents of that exhibit, can court decree this way? Number 1 is mere producing without following procedure. That is, here in this case, procedure has not been followed at the time of exhibiting that document. Number 2, even if it is produced, the contents of that document has not been proved.
Now, whether we have to, at this stage, we have to look into whether it
Yes,
was,
contents of the document.
no. Whether it was followed on the question of fact, whether we have to look into.
It is not question of fact. I have shown from the record that in the plain, what they have produced, and in the exhibit, what they have produced.
This inquiry is also a question of,
No, it is not a fact. It is the question of perversity. The trial court has not gone into the entire records in its entirety. It is called perversity. And perversity,
perversity is not.
yes, it is
perversity
a question
not
of,
ba-
it is a question of law,
That not based on evidence.
not based on evidence. Perversity. It is not neither or not based on evidence, nor
Whether
without,
evidence was there or not.
Whether
This
it-
inquiry is a question of law or question of fact.
it is question of law. Perversity. Suppose X is there. If I read it Y, it can be, it is a question of law. If suppose X, K is there, I read it as X. It is also a question of law. Because it is perverse, it apparent on the face of the record. If it is apparent on the face of the
I
record,
want to understand fully the meaning of substantial question of law. In 100, we have to confine ourselves only to substantial question of.
perversity is a substantial question of law.
What do you mean when you say perversity?
Perversity means in the plain one thing they have produced. And when it come to the evidence,
Perversity means not based on evidence,
not based,
not based on evidence,
as not based on pleadings as well as in evidence.
not pleading. It is perverse means something which is not supported by evidence.
Yes. Not supported by
Supported
evidence.
by evidence. Now, that inquiry, whether it is supported by evidence or not, it is an inquiry of fact which first appellate court has to go into.
First appellate court has not entered all this aspect. That is why I initially submitted that first appellate court has not gone in any aspect of the matter. In a wrong direction, it has been passed. In that case, it is a case of remand. In that case, it is a case of remand. And why I am submitting on with respect to admissible evidence, if it is a case of remand, then we will not be prejudiced because we have already deposited the amount before this honorable court. Rather, they will be prejudiced by not getting their money or legitimate claim by not getting their. That is why my submission is that if your lordships is convinced that there is a lacuna in passing the trial court lower appellate court judgment, it may a case of remand. Clear-cut case of remand. For the interest of justice, I am saying that on the basis of admissible evidence, court can mold the decree also.
In second appeal,
In second appeal. Or
where
if
is the authority? Show me the authority, what this court can do in second appeal. From the very beginning, I am asking this question only, that I don't want to cross the boundaries of section.
then in that case, I will confine to my earlier argument that the trial lower appellate court has not considered anything. So it is a case of remand. Nothing else. Because if your lordships entered into whether this second appellate court can enter into whether this document was duly proved or not, whether it was in the plain and in the evidence, in that aspect,
That is the role of first appellate court.
first appellate court.
But whether in second appeal, it can be looked into or not. If you can
It
show
can
it,
be looked into in the second appeal
show
also.
me the.
Kindly see section 100. 5. Section 100, 5. I think 5. No, not 100.
Read 100
No, no,
entirely. Only this substantial question.
107 can be seen.
100,
7,
107.
107. Power of the appellate court. Subject to such condition and limitation as may be prescribed, an appellate court shall have power to determine a case finally. Lordship got it?
Yes.
Number 2, to remand a case. Number 3, to frame issue and refer them for trial. Number D, to take additional evidence or to require such evidence to be taken. Subject as aforesaid, the appellate court shall have the same power and shall perform as early as may be the same duties as are conferred under imposed by the court on court of original jurisdiction in respect of the suit instituted therein. This is the power of the appellate court.
Read 100.
Now 100. Second appeal. Save as otherwise expressly provided in the body of this code or by any other law for time being in force, an appeal shall lie to the High Court from every decree passed in appeal by any court subordinate to the High Court. If the High Court is satisfied that the case involves a substantial question of law, an appeal may lie under this section from an appellate decree passed ex parte. In an appeal under this section, the memorandum of appeal shall precisely state the substantial question of law involved in the appeal. Where the High Court is satisfied that substantial question of law is involved in a case, it shall formulate that question. The appeal shall be heard on the question so formulated, and the respondent shall, at the hearing of the appeal, be allowed to argue that the case does not involve such question, provided that nothing in this subsection shall be deemed to have taken away or abridged the power of the court to hear or reason to be recorded the appeal on any other substantial question of law not formulated by it, satisfied that this case involves such question.
So the question, even if it is not formulated,
Then also, if your lordships are found that this substantial question of law is required to be heard, that also can be formulated at the time of hearing.
what is substantial question of law?
Substantial question of law is the question of law which involves in the case for determination of the case.
What is the difference between question of law and substantial question? Because if a question is not a question of fact, it may be question of law.
That judgment I have.
Why the word substantial word
was
adjective
used.
substantial has been.
That judgment I have, my lord, but today I have not brought that judgment. I have that judgment. I have actually, I have not thought that this question may come. That what is the substantial question of law?
Yes.
That
This
is,
this is the most pertinent question.
that question may I submit authority. I will. Today I don't have the question which involved in the case is the law for determination of the case in respect of the law. It may, in other case, it may not be a substantial, but in the present case, it may be a substantial, which in the question which will change for determination, which will change the determination finding. Suppose one point has
You
not
are here tomorrow also.
tomorrow. Today I am.
How much time will you take?
I will take hardly half an hour or.
Because he is not yet finished and we have dealt with only 1 out of 11 cases. In other cases, exhibits are different exhibits.
Yes, Lord.
Yes. Exhibit are different, but
Almost
line of same. Maybe in
But
my
you are referring to exhibits.
exhibit
They-
in referring, here in this case, I am suppose referring exhibit 1 and 11. In other case, it may be 1 and 12 also.
That you have
That
to
is-
make clarify. Because when I start writing judgment, these questions I will face. Because therefore I'm asking what is substantial. You are taking me into facts. So
Then I have marked also in all the cases. At the time of admission, I have flag mark, whether it is there or not. Tomorrow I can again flag mark it.
no, flag marking will not do. Actually, one small gist, case-wise gist, that in this case, your submissions, bullet points are submissions. Apart from memo of appeal is there.
I have understood.
You have understood.
My lord,
That's,
can it be possible by giving copy to other side? I can hand it over to Guwahati on Monday.
then I will postpone it.
No, before bullet point, I will hard copy.
I can
to-
keep it part hard, but there is no
Yes.
guarantee that I will come back here very soon.
Let's try Lordship.
My lord,
Whether I
can
keep
it
a
be,
part hard.
maybe part hard, my lord, it will be convenient for us also,
Yes,
because
because
otherwise.
every time
Every
Lordship
time,
come, other
Therefore,
Lordship come, cannot complete and
There-
again.
Therefore I agreed to hear the matter.
no bullet point, actually, here I have no such.
Because Lordship, how much today we can complete the hearing? Because I have already submitted letter of absence also for tomorrow. So I'm
Okay.
going here.
Then let us hear till 4:30. I
Yes,
will keep it part hard.
yes,
And what you have to do, I will dictate in judgment,
yes, Lord.
in the order. You have to give me gist of the orders.
Yes,
Gist of your submission in bullet point.
yes,
And because your submission will be different in all 11 cases, will be referring to different exhibits.
yes.
Only other point will be remain same, only exhibit number may be different.
Because amount.
Amount,
decretal
amount will be
is-
different. Yes.
Decretal amount is different.
Different, different. Decretal amount is different,
And if.
exhibit number.
And if this appeal can be decided without referring to those facts,
Yes,
if it is your submission that without referring to those facts, appeal can be decided, then I am ready to hear that without specifically going into facts. Therefore, my query was, what is substantial? You have to make me understand what is.
So regarding first substantial question of law, your lordship will have to look into the exhibit.
Exhibits.
Because.
So your submissions have to be clear.
Because
Otherwise, once I
No.
conclude the hearing, at the time of writing judgment, I will face these difficulties,
Hmm.
and then judgment would be delayed.
no, it is, right.
So I need clarity.
yes, we can make Lordship part hard also, no problem, whatever. time.
Tomorrow
But,
I'll make it up. Oh, tomorrow you will not be around.
So, okay, then we will stop. What do you propose? Because you have to be clear what you want, how you want to make the court convince. What are the queries of court you now understand?
Hmm.
That you have to go step by step, that this is a second appeal which involves substantial question of law. This is the court's jurisdiction. This is where because at the time of writing judgment, if I come to finding that the questions which are formulated are wrongly formulated, there again this, because he will be arguing that these are not substantial.
Not substantial.
That is this, on that point only you will be arguing.
yes,
that these are wrongly formulated questions that he can argue. These are not the substantial question of law which are involved.
Yes.
So you're.
No, I will,
in
I
that
will
case-
not argue beyond the question which has been framed.
Not
I
No,
will
he
not
will
argue.
say that these are not,
No, he may
These-
say, he may. it is-
because
it is his-
statute gives him that right.
No, it is his submission. He should be submitted that it is not in accordance with.
So
So, we-
what I want, I may release it, I may do, I have little bit understood the facts of one case, which I suppose similar in all the cases,
Yes,
except the,
Yes.
except the, and the points on which you are hitting, that I have understood, but I want to know that whether these are points of law or points of fact, or mixed question of fact and law. Whether at this second appellate stage, I can go into those issues or not. So what I want that you give a gist of your argument.
Yes.
And wherever your argument is different in different cases, in case number 1, you make a general argument, you have already made an argument. What is different in case number 2, case number 3, case number 11, that you have to mention,
I will mention.
which you want to be reflected in the judgment. That assistant
Yes.
is required.
In that case, Lordship, my suggestion that we can stop here and make it a part hard. Meantime, we will submit all the gist of the case.
That can be
Yeah,
done.
yes.
That I leave it to you because
Yeah.
I'm not sure when I'm coming back.
Yes,
No, your lordships will be coming back shortly.
So, no, because otherwise it will be keeping part hard means tying with a particular judge.
Actually, what happened otherwise also, earlier also it was hard. Then on last occasion when I have came, that court says same problem. Tomorrow I will be leaving. So if we hard, we will have to carry out the entire file to Guwahati. That's why it has been deferred. This way is going on.
And
In
it will,
the, in the process, we are not suffering actually. Suffering is from their.
no, it's all,
They are-
all
Yeah.
right, no problem. No, how?
they are
So
suffering
since
because
2013, we are. So Lordship,
our-
if whenever
our-
you come back,
because
so matter can be
amount
again hard
we
and
have
can
deposited
dispose of.
with respect to
Hmm.
admitted amount. So question of interest may not be arise after deposit. Before deposit it may, but after deposit may not arise. For that purpose, they are suffering. They are not getting their money in the process.
No, whatever the, as per their,
This is not our sufferings.
so
is
decree
why
is
I
not
am
the,
saying-
not the 99,000. Decree is 3,78,000 Lordship. So 99,000 may not be get the interest, but other I have, if Lordship dismiss the appeal, then the respondent will get the interest as per the decree passed by the learned trial court, but not for the 99,000 when he was when the appellate is deposited. The rest amount can get. So my humble submission, Lordship, make it a part hard. So whatever time may be taken, whenever Lordship come back, matter will be listed and we can make a final attempt to dispose. Otherwise, really, last occasion, Lordship,
Only-
court also already heard. Later on, he has released. At the time of releasing, he has proposed new substantial question of law. That is a
No,
which was
that-
paid.
that is-
That's why
Law-
this way,
Law
this way
says
the
so.
order speak because
No,
I
no,
don't
law,
see-
law says so.
So.
100 is, there is
even
a,
at the time. of
even
the-
at the.
August,
it is-
that is more than 1 year back. It's supposed to be disposed of,
No, it is
but
100, as per 100.
so.
Even at the time of argument, today
So
also.
I leave it on you.
Yes.
If I make it part hard, I have to come back within 3 months because more than 3 months
It cannot
be
be.
tagged. Attached. After 3 months, it would be automatically detached. Before 3 months, hearing has to be concluded.
Yes.
If
As per
lordship
notification.
not able to come within 3 months, it's all right, no problem. But if comes, lordship,
Then let us stop here.
yes, Lord.
And you have understood my
Query.
Point.
queries and concerns that here most probably either the court has to write 11 separate judgments or a common judgment.
So separate judgment require, this will be
If
required.
separate judgments are required in
Ah.
separate cases,
Yes.
then your submissions have to be on that line. A common thread argument has to be there, but in this case, these are the.
Factual part,
So separate gist of 11
No,
cases. would be required.
I'll prepare on next date.
Otherwise, what
with-
will happen even after hearing both of you
Yes,
at the time of writing or dictating judgment,
yes.
I would get, any court would get difficulty.
Yes.
So
We'll
you
prepare it.
give separate gist of arguments, though these cases are tagged together.
One general argument and another in the facts I will
Here,
separately.
the separate orders are passed in,
Yes, separate order.
okay. But councils are same.
Yes, Lord. Council, sir.
So today, write a common order. Copy of the same should be kept in all
Yes.
the appeals.
Only number will be changed.
Number will change. Or in top of the order sheet, you can mention all the numbers.
All the numbers also. Yes.
Keep one copy in every. Heard. Mr. From item number 10 to 20. Mr. S.K. Ghosh, learned counsel for the appellant. Also heard Mr. Mudang Bhatt,
Yes, Lord.
learned counsel for the respondent number
One also.
1,
Yes.
and government advocate is also appearing. And heard Mr.
I Ram.
2 and 4.
I.L. Riram. Heard Mr. I. Riram, government advocate Arunachal Pradesh, for respondent number 2 and 4. Hearing remain part heard. Hearing remain inconclusive. The counsel for the parties are requested to submit written gist of their argument in each of these connected cases on the next day. The hearing remain part heard. Let this matter be listed again whenever this bench is available. Because I cannot fix it
Yes, Lord.
whenever this bench is available.
Most.
Much.